A few housekeeping points before I introduce the speakers. We will speak for about 45 minutes, followed by Q&A with the attendees. This session is being recorded and the recording will be made available after the session concludes. If any of you who are joining us live would like to raise any questions, you can do so using the Q&A function at the bottom of the screen. I will keep some free time at the end to put your questions to the panel. All of the speakers here tonight are from our barristers at 36 Commercial. We are joined by Michael Patchett-Joyce and Paul Schwartfeger, who will start this webinar by looking at real-world application of smart contracts. Then Paul and Fergus McCombie will look at terms and functionality of a smart contract. Fergus will then continue the discussion with Joseph Dolby SC by looking at performance and breach. And finally, Joseph and Michael will look at enforcement and dispute resolution. With that introduction, I will now hand over to Michael and Paul.
Sajid, thank you very much indeed. Ladies and gentlemen, it's often said that smart contracts are multidisciplinary. They combine law, tech, and the discipline to which any smart contract relates, be it finance, property, or whatever. So I'm therefore particularly delighted to be joined in presenting the first part of this webinar by Paul Schwartfeger, who has high-level tech training expertise and experience before becoming a barrister. Now, Paul and I are first going to address what appears to be a simple, but is actually a rather challenging question. What is a smart contract? Is it a contract? And where does the smartness come in? We'll then look at some of the can-dos and can't-dos so far as smart contracts are concerned. I thought it might be helpful if we began with a definition, and I've taken a definition from a very frequently cited article by Werbach and Cornell, 2017 in the Duke Law Journal. In their article entitled Contracts Ex Machina, they defined smart contracts as, quote, self-executing digital transactions using centralized cryptographic mechanisms for enforcement. Now, we might unpack some of the particular aspects of that definition. But Paul, let me just encapsulate the whole definition again. Self-executing digital transactions using decentralized cryptographic mechanisms for enforcement. What is your general reaction to that definition?
I think on the whole, it's a good paper, but I do have a bit of a problem with the definition, particularly now that we're 5 years on from it having been made. It is somewhat over-engineered. It's also somewhat zeitgeist. It really is structured around the buzzwords of the time, in my opinion. Blockchain and cryptocurrencies are used extensively in the paper, but smart contracts are obviously not just the preserve of blockchain. And the use goes far wider than cryptocurrencies as well. There's no reason, for example, why a smart contract couldn't exist in other forms of distributed networks, or even, say, in a computer running in an office somewhere, depending on what its purpose is. And those sorts of alternative technologies and hybrid solutions could actually help overcome some of the legal challenges that certain technology sets present. So I'm thinking here about issues like immutability when a smart contract is stored on or interacts with the blockchain. Blockchain's a sensible choice if a smart contract needs to be tamper-proof, but it's perhaps a poor choice if the contract has an error in it or if it needs to evolve in terms of its terms over time. I think Werbach and Cornell also overlook the realities of the data sources and transaction endpoints that are necessary really to give smart contracts any value in the real world as well. Things like input data and the copyright issues that can arise from those, and also system uptime concerns.
And I think there are probably at least one trap for the unwary in the definition that we've just been looking at, which is the word transactions, because transaction technically can simply mean a step in the process, whereas a transaction to a lawyer really very often means the contract as a whole. So do you see the sort of terminological difficulties in this whole area?
I absolutely do. I know even from our discussions about these things that we all bring to these discussions our own vocabulary and our own language. And this is perhaps some of the problems that can arise in terms of trying to define a smart contract, because we may take a very technological view and talk about transactions, as you say, as a line of code or an interaction within a code, or we might be talking about a complete arrangement of affairs between parties, as lawyers might be more inclined to describe them.
And I suppose the other word that I'd pick up on in the definition is decentralized, because that obviously makes one think about the decentralized ledger technology, blockchain. But you were saying, well, it could run even just within an office. Now, does that make smart contracts, in a sense, more usable, in a sense, more accessible than people might have thought?
I think it's going to change the nature of the contractual arrangements and what is and isn't possible. So being wed to any one technology set is often problematic, because there will always be limitations with certain technologies. And it may be possible to overcome them by switching to different forms of network or different forms of technology or different solutions altogether. So it's not necessarily that it's going to be a better solution, it's just going to be a different way of doing things. And companies and lawyers certainly need to be thinking about, well, what are the best ways to achieve the ends that I need? What are the best ways to ensure that my contract is robust and performs as expected, and not simply to anchor to a particular technology set simply because it's zeitgeist or that's what people are talking about at the time.
And you said it might be an over-engineered definition. Is it going too far to go to the opposite extreme, or is it simplistic to say, well, really, a smart contract is simply a bit of code and it's running on a fairly basic if ... then ... logic? Is that too simplistic?
I quite like that as a starting point. I don't think it's too simplistic at all. It's one that we can, as far as definitions go, layer sort of the legal and practical realities onto to start seeing where the issues might lie. So it's helpful, for example, as a definition to shine a light on the missing parts for a legal contract. Offer and acceptance and the like, how might they be encapsulated in a contractual arrangement if you're looking at it in simply those procedural terms? It also conceptualizes the code very much as a sequence of statements. If an event occurs, then do something. And a smart contract that's framed in those terms is very obviously all about performance. Now, distributed networks are used to ensure that the code runs when it's expected. But if that performance is permanent and unavoidable, and there haven't been other factors, necessary ingredients in the mix, such as consideration, for example, then that performance could be unlawful or problematic. So those are the sorts of issues that I think a very simple definition, which you start layering up, can be helpful for.
Now, I know that you and Fergus will be looking at performance in a bit more detail in the next section in terms and functionality. Let's turn to what smart contracts are good at doing and where they actually come up short. If we start off with two overarching points. First of all, they can save transaction costs, particularly in the context of something which is a repeat exercise and which is very formulaic. Secondly, they are modular and therefore they're capable of being built into libraries and suites of modular sections which can be put together to form a smart contract. Are those a couple of good starting points in terms of what smart contracts can do?
I think they are good starting points. I mean, one thing that does need emphasizing is a smart contract can only do what a computer do. So a smart contract cannot, for example, enforce performance when it comes to human actions. But the way that you've framed them certainly raises some interesting considerations. So for example, if we're talking about lower transaction costs, this is probably by means of reuse and greater efficiency. So the parties to a contract might be able to, for example, reduce their costs by assembling modules of contractual components together as you described. And that's attractive, but it could create power imbalances potentially, particularly if one party to the contract doesn't have the resources to be able to propose an alternative, create an alternative, or even to understand the contract fully, given that it exists in computer code. I think it's also worthy or worth considering the fact that computer technology develops at such a pace that problems could arise in terms of compatibility issues down the line. If we think about a smart contract that's intended to operate over several years, that sort of modularity or that sort of system could prove problematic if different modules come from different vendors and each have different upgrade paths. So as lawyers, we really need to be thinking about the entire life cycle of a smart contract and not just its terms necessarily. We also need to think about how these things come together and how they're going to survive for the intended duration.
So there's a risk of sort of accelerated obsolescence in this whole area, which everyone should be on their guard against. But if we're looking at concrete examples, then one starting point that I came across was to ask the question whether a smart contract can help wherever there is economic information and theories that can be modeled and specified in a computable way. And I suppose the two paradigm examples would be, in the one sense, financial services, where you can have a whole range of aspects dealt with falling within that broad definition. So securities clearing and settlement, collateral management, derivative contracts, security asset servicing, international money transfer, all of those aspects can be tied back to what I've just said. And the other paradigm example is any transaction involving a register or a record, such as the sale of registered land and the changes that that necessitates on sale and purchase within the land registry. I suppose if we're looking at other aspects where smart contracts can help, they can help in relation to IP rights, gathering together royalties. They can certainly help in relation to supply chain management. And that, of course, is going to be very important with free trade agreements, not just the trade and cooperation agreement with Europe, but other trade agreements around the world. But I think there are also some unexpected areas where perhaps a smart contract falls short. And I came across one example where an insurance contract had been trialed, and one may think that's, again, a paradigm example of if an insurable event occurs, then there is insurance payout. But in terms of writing a digital contract sheet and basing the whole thing on an Ethereum contract, it was found that it simply didn't work because there was a real challenge in translating natural language into coded language with sufficient specificity. Now, we've dealt with some can-dos. Time presses, we can only deal in summary form with some can't-dos. Smart contracts can't cope with subjectivity, good faith, reasonable endeavors, best efforts. Can't cope with other aspects where there are clearer words. Delivery, for example, could pose a challenge. Relational contracts, ongoing contracts where a relationship between the parties is necessary, and where there are vitiating factors like duress, unconscionability, illegality, public policy, and even voidable contracts may pose a challenge for smart contracts. I hope that provides some context in this first section. I'm now going to step back and let Paul and Fergus look in more detail at terms and functionality of a smart contract in the next section. And I'll be rejoining you later with our colleague Joseph Dolby, Senior Counsel, to discuss dispute resolution. Thank you very much.
Thank you very much, Michael. So one of the things that's come through very clearly from the discussion between you and Paul is that the safest and best way to think about smart contracts and the terms of them and their functionality is usually going to be that the smart bit, the self-executing part, will usually form a greater or lesser portion of a wider set of arrangements between parties. I say safest and best because if you think of smart contracts in that way, it's clearer to see how the self-executing bit will sit somewhere on a range of possible models. And one extreme would be an agreement which is largely written in natural language with just the performance part automated. So in that case, the smart aspect of the contract is relegated just to a particular mechanism the parties have chosen to achieve the desired result. For example, royalty payments is the example that Michael used. At the other end of the range would be what's sometimes referred to as a smart contract written solely in code. And there we're talking about a contract where there's no natural language version of the agreement between the parties. It is solely as code, probably on the distributed ledger, but it need not do so. And in the middle, which is the widest part of the range, sits a whole series of hybrid concepts where some parts of the contract are written in code and some are written in natural language. So Paul, just in headline terms, can you describe some of the issues that are going to arise if we try to start analysing smart contracts in traditional legal terms?
Well, I think the point to be made here is actually that the UK Jurisdiction Task Force tells us there's no real reason in principle that a smart contract cannot also be a legal contract. So there's no reason that it cannot therefore be legally binding. I think if we think about these things practically, we already form contracts over the internet regularly when we click the buy now button on a given website. And somewhere in that process, acceptance of an offer occurs. Now, those steps, they might not necessarily be smart or part of what we would describe as a smart contract per se, but they are computerized. And given the direction that's come from the UKJT, it should therefore be possible to move more of those contractual ingredients into the smart contract bit. So the smart contract code could handle acceptance or provide consideration, for example. But I would hang a bit of a question mark over the intention to create legal relations bit. This is probably going to be via some kind of proxy where the human intention or the human element is carried forward in computer code or something like that. So I think there are still areas within the traditional legal terms that we need to give consideration to as we try to translate them into a technical environment.
Yeah, and we will come back to the question of intention to create legal relations. But just thinking about a largely natural language agreement with automated performance, there are going to be difficulties there which might arise from being unable to prevent performance if some extraneous event occurs, such as an undiscovered breach on the part of the receiving party. Because in traditional contractual arrangements, the innocent party's slow, boring traditional processes are going to give it time to discover a breach and say performance or payment to be withheld at that point. But with a self-executing smart contract, there are going to be a number of additional hurdles before the innocent party is going to be able to do anything about the problem. And those are going to stem from the very automaticity, which is touted as the major advantage of using smart contracts in the first place. So firstly, the smart contract might already have self-executed. The boat might have sailed, unlike the Ever Given. And secondly, the burden of stopping or preventing execution in some machine-related way is something which the innocent party may not have the capacity or the expertise to achieve at all. So that seems like a good moment to bring in the concept of due diligence in respect of the oracles applicable to the smart contract, by which I mean the external data points that are going to trigger events under it. And that goes wider than a largely natural language agreement, but it's perhaps all the more clear in that sense that the external source triggering performance needs to be clearly captured in a common intention by both sides. So now that I've introduced that concept of an oracle, Paul, can you explain a bit more what we mean by that term?
Certainly. If we take things back to the definition that Michael gave, the earlier suggestion that smart contracts are a series of if some event occurs, then perform some action statements. Well, that some event within the statement, that might be able to be encapsulated within the smart contract itself, and it might also be able to be verified on the platform that the smart contract's been developed on. So for example, platforms generally have a concept of date and time. They're aware of these things. And so they could trigger an action at a set point in time, say take £10 from a customer's account on the first day of each calendar month. But many of the sorts of events that a smart contract might want to act on might be external to the smart code or its platform. And those external sources tend to be dubbed oracles. So if we think about the example of, say, a smart contract for motor insurance, it might want to receive or take information from an oracle, perhaps to verify that a car that a policyholder is making a claim for has actually been written off or stolen before it pays out. Now, that data source that provides that information, we would, as I say, refer to as an oracle, but it could be problematic if you don't have any influence or control over those third parties or those oracles. And it raises questions about how you might perform due diligence for them. So can you trust that the oracle you want is actually there when you need it? Can you trust that the oracle's data hasn't been tampered with before you get it? And issues also arise with oracles if they change after the smart contract has been made, and in particular, if the smart contract code is immutable. So thinking again about our annual car insurance example, the code's going to be regenerated each year potentially. It may not be such an issue if things change and you have forewarning or notice of them. But longer term policies that people might be entertaining or contemplating putting onto the smart contracts, things like life insurance could run into serious problems, because you could see that after the contract terms had been set and the technologies had been determined and the oracles had been chosen, it might be some 90 years before the person who took out the policy dies, and the events, triggers, and oracles may have changed in the meantime.
Yeah, Yeah, so to come back then to the features of different models of a smart contract, and thinking particularly about a solely code contract. In that case, there could be serious issues about ascertaining when the contract is said to be formed in law, whether it's formed in law, how does the intention to create legal relations fit into a solely code contract, and how can the terms be captured? I think this is where considering the use classes of a smart contract might yield different answers. That's because in a business-to-business context, commercial due diligence might well require the party that didn't create the code to inspect the source code to verify it. Many of you will already be familiar with software as a service agreements, which allow the customer to inspect the source code without having any entitlement to amend, of course. And if that were feasible, it might quite often be said in a business-to-business context that both parties know exactly what the code says and does because they're taken to have verified it. Paul, do you think that kind of provision in a B2B scenario is likely to be sustainable?
It could be very problematic, actually, as smart codes start to become built up from modules, for example, and you get reuse and repetition of code blocks. That could cause problems in terms of those modules potentially being developed by different vendors, those different vendors having different licensing or inspection rules. And I think some of the benefits of smart contracts and that you can potentially have this reuse to bring the costs down may be outweighed by the issues you will have with due diligence, trying to figure out what one module is doing with the next and so on and so forth in a chain. It could prove impossible.
And anyway, clearly that kind of approach isn't going to pass muster in a consumer context. So it may be that in the consumer context, or even in some B2B contexts, some kind of natural language explanation of the workings of the smart contract might have to be in place, and then query whether the natural language explanation is the contract or whether there's something lying underneath it which forms the contract. And as for the intention to create legal relations, well, you might say that even if the smart contract is wholly in code, there'll always be some sort of natural language negotiation which could be used to ascertain what the terms of the contract in fact are in law, so that the problem's one of evidence rather than principle. But this is potentially a trap for the unwary. Would you agree with that?
I would. This actually goes to the issue that events, they may be triggered as intended by oracles, but they could also be triggered inadvertently or perhaps even fraudulently. You know, if they are just endpoints in a network somewhere, and all that needs to happen is that someone calls a given address for that endpoint or that oracle to make something happen, then you can see that if the address was stumbled across inadvertently or called fraudulently, then it might create a sequence of, or cause a sequence of events to fire and performance to be executed, even absent any real intention to create legal relations.
So the issue that arises is at what point and whether at all the parties have chosen to interact. And there are a number of connected problems arising from that. Potentially not knowing the identity of the other party, which is obviously problematic when remedy is being considered. And in a solely code smart contract, an intention to create legal relations is going to have to be inferred from conduct, but what kind of conduct in a situation where execution has come about by means of interaction between code? Placing the code on the chain in the first place, or some other kind of conduct? These are the kinds of difficulties which case law ultimately is going to have to work out. We're going to just briefly mention contractual formalities. And Paul, just for example, could a smart contract satisfy an in-writing requirement?
Well, the jury's somewhat out on this one, in that we need to determine whether or not the computer code is decipherable and if it's in written form. But I think the important thing to stress here is we're not talking about digital signatures or electronic signatures being legal. Those arguments have already been resolved. We know, for example, that the Land Register has accepted electronic signatures since July 2020. So when we're looking at formalities, they run deeper than just those sort of superficial issues, and context will be quite important, I think, to understanding whether or not, say, an in-writing requirement is satisfied.
Yeah. And there's another type of formality which I describe as the effect of regulation. In a business consumer context, transparency and fairness are going to be important, and that may be difficult. There may need to be some kind of verifiability of the smart contract somewhere. There'll be GDPR issues in cases of smart contracts that are going to arise. So when we talk about functionality in terms of a smart contract, I'd sum up the various issues we've touched on as being really about verifiability, and that's it in three particular ways. Firstly, verifiability that a contract in law even exists, coming back to the intention to really create legal relations points. The second is verifiability of the terms, bearing in mind the extent to which those terms are written in code. whether to a greater or a lesser extent. And the third is verifiability for the purposes of regulatory transparency, business to consumer, GDPR, issues of that nature, formalities of that sort. So as to the question we've asked ourselves in this talk, are smart contracts as smart as the people who wrote them? The answer appearing from considering terms and functionality would be that they're just as smart as each other, as long as the terms and functionality can be verified. So with that, I'm going to say thank you very much, Paul, and bring in Joe Dolby, who's going to discuss with me some issues surrounding performance and breach of smart contracts. And Joe's going to take it forward, particularly in respect of business interruption and system failure. But just before we get there, I'm just going to add a few words about performance and breach in terms of the interpretation of the smart contract, the kinds of questions that arise from considering the terms as per the discussion I've just been having with Paul. So thank you, Paul, for that.
Thanks, Fergus.
And just a few comments on that narrow conception of breach of a smart contract. As we've been discussing, those issues of interpretation sit at the interface between the code of the smart contract and a natural language interpretation, whether the natural language is contractual language or whether it's something less. Computers don't go off on a frolic of their own. I'm a fan of Star Trek as much as the next man, but we're not quite in that situation yet. They do what we tell them to do. So when we're talking about difficulties of performance and breach, we're really talking about a situation in which there's some conflict between code and the expectations of the human actors involved in making the contract and performing it. In standard software as a service contracts, there'll often be terms where the performance of the software isn't guaranteed, query the applicability of that kind of term to a smart contract and how useful that kind of term will really be, where the whole point is automaticity and self-execution. But there's perhaps an even more fundamental conflict at work when it comes to assessing what the smart contract actually means in a legal sense. And one suggestion might be that what you need to do to ascertain what it means is to look at what the code actually achieves in practice, versus an approach where it says you look at what a reasonable person with knowledge of the code would say that the code would achieve. Now, the advantage of focusing on what the code actually achieves in practice is certainty. It comes back to the point that the computer will just do what you tell it to do. But the disadvantage is that it has a whiff of circularity. The problem there being that if a problem has arisen in performance, if you could explain that away simply by saying, well, that's what the code achieves, then it's not really an exercise in legal interpretation at all. So I'd venture to suggest that the right approach remains to look at what the code says to a reasonable person reading that code. Obviously, it has to be someone with knowledge of the coding language. And that's because that preserves the principle that a legal contract is fundamentally a meeting of minds or an accord at the level of an exchange of promises between actors. So, Joe, moving on from there, can you take us further with the questions of system failure, which go beyond those narrow questions of breach in that sense?
Well, yes, certainly, Fergus. I mean, you're touching on a number of things that rely upon the functionality of the code and its interaction with other systems. So, in that sense, the key to successful performance is the technology upon it rests. So we're concerned here with, in the case of non-performance or performance of the system in a way that is not intended but not contemplated as a breach due to circumstances beyond control of either party. In essence, failure, and you referencing a computer can only do what a computer is told to do, but there is that old saying that to really foul things up needs a computer. So when we look at that aspect, we're really concerned with force majeure and frustration, for which there's bundles of jurisprudence available. It's only touched on in the legal statement, which says there will always be a risk that performance is affected by an event external to the code, for example, system failure, or that the code operates in an unexpected or unintended way, and in such cases, any dispute must be capable of adjudication. Whereas, as you know from the legal statement is preoccupied with wargaming, Alice and Bob scenarios about formation and intention and construction, things we've been talking about with Paul, and all of which are going to be relevant to the issue of dispute resolution and enforcement. But in a sense, system failure doesn't get a fair hearing in the legal statement. But having analysed what you've done with Paul, that there's a high probability that once a smart contract code is identified as having been created, either creating a contract or incorporated into an enabling contract, and whether or not it's readable may be another question. But then anyone faced with a bad bargain is probably going to try to blame it on the system. So let's look at, firstly, force majeure.
Yeah, so Joe, how can you translate the concept of an act of God into code? Or would that kind of term have to form part of what you call the enabling contract, the natural language part of a contract?
Well, that's right. I mean, we've made reference to the if ... then ... scenario. And if we put up slide 1 now, when I refer to force majeure clauses, I'm just in that category of terms that deal with foreseeable but improbable events that has a condition precedent to steps aimed at excusing non-performance. But that takes a new significance in relation to system failure. So, I mean, how would you, from taking that if ... act of God, what would then happen? Well, you obviously will need some sort of additional mechanism to deal with exactly what we mean by an act of God, and I will be looking at those sort of mechanisms that can be used in order to deal with that. But what you have there is a visualization of the smart contract code element that will deal with not just processing a programmable transaction, but also, if it's going to be deal with it at all, to deal with system failure. Now, the other aspect is frustration, which again, delegates will know that is that doctrine of contract discharge that's evolved through jurisprudence, and that will determine liability, where liability falls in the event of a supervening event resulting in possibility of performance, which is not already successfully provided for within the contract itself. And we can take the COVID pandemic as an example. The key question then is, in those sort of scenarios, is it dealt with by the smart contract or is it dealt with elsewhere? The cause is, what is the cause of non-performance? With smart contracts being programmable transactions, the obvious cause of non-performance for extraneous events will be technological breakdown. Now, we should be cautious about stating the probabilities of a system failure, especially with regard to distributed ledger technology, which is supposedly inherently decentralized, supposedly making them all the more secure, tamper-proof, and immutable. Now, that may not be the case, particularly in the early in a ledger's existence, and Forbes reported in 2019 of a high level of partial failure connected to widespread experimentation, not just in blockchain, but else in other systems as well, but that may be part of the course. Beyond this, the vista is of a major or complete system meltdown with colossal or devastating consequences, and that may be associated with hacking or data breaches. But anything, and we've seen instances at Heathrow, with O2, with the banks, TSB and HSBC, of that sort of thing. So that is quite widespread and impactful. But we must also be concerned with more system failure caused by an incident that is firstly localized, time-related, whether either human or automated decision to acts are done on assumptions that are made at a faster rate than the ledger can keep up with. Now, those causes of partial or local system can arise in a variety of situations: non-performance, delay, false positives, an event not being recorded, an event being deleted, human error, of course, and hacking. And these are going to, in my suggestion, are proportionally more prevalent or impactful with smart contracts than program transactions on a centralized platform. And you'll see from the the diagram there, the slide there, how that's represented. As the diagram depicts, system failure can occur at the center of a centralized platform affecting all transactions, or a failure could be on any one limb. And this demonstrates that we are concerned with non-performance during the performance of the smart contract as opposed to the enabling contract. And if you bring the slide down, please.
So, Joe, to what extent can some of those issues be controlled by the enabling contract, or indeed the natural language contract, or does it have to be controlled from within the smart contract?
Well, I think they can be extensively controlled or regulated or dealt with or resolved by the enabling contract, and one might say that it will have to dealt with at that stage because it would involve interaction with other mechanisms. At the same time, they would have to be actioned within the smart contract itself, either before the smart contract is programmed and deployed, or at the point at the time the dispute arises. And I think this is what we're really concerned about. And so we're going to bring Michael back in to deal with disputes and how they can be resolved between the parties in the event of system failure. So thanks, Fergus.
Thank you.
So there are various smart interventions that are available. We've got self-correcting mechanisms using, for example, decentralized autonomous organizations, which gets an honorable mention in the legal statement. The core value of these organizations is no one entity has the authority to make and enforce decisions. That is a value, obviously, that could be applied in relation not just of breach, but also non-performance, where rules are preset, decisions made objectively, subject to predetermined criteria. But as I say, requires some sort of human intervention. Then there's something that Paul's mentioned, automated oracles, which can be used for verification within the programming of the transaction, but could also be used in conjunction with some third-party or ADR or online dispute resolution. The essence there is events unforeseen at the time coding, that require outside verification will use oracles to receive external data to resolve the situation. The oracles would input their causes of non-performance from outside the chain, resolving the force majeure issue. Now, it could also be used possibly for frustration type disputes. For example, contracts rendered impossible as a result of the COVID pandemic. A dispute resolution at Oracle could allow external experts or mediators to affirm the existence of a pandemic and the party's inability to perform by an outside date or inability to perform at all, and then automatically resolve, say, the return of funds or the relief of performance of the underlying smart contract. Then there are on-chain dispute resolutions, but here we are in effectively choosing our forum and whether it's an online dispute resolution that will be internal to the smart contract. Alternatively, if it's not available by interaction with a online mechanism, then I suppose we are into the real world courts, probably the TCC, where we need more extensive powers in respect of disclosure and enforcement, but obviously at a price and duration. And there is a earlier seminar in the system in this season with relation to the powers and the applications that can be made. What there is, though, is a set of draft digital dispute resolution rules, which can provide draft rules for arbitration pursuant to the Arbitration Act and offers a decision within 30 days. Michael, you know something about those.
Joseph, thank you very much indeed for bringing me back in to say a word or two about dispute resolution in general, and in particular, the digital dispute resolution rules, or draft digital dispute resolution rules as they are. It's a pleasure to be rejoining you, but before I go on to the rules, let me put dispute resolution for smart contracts into a little bit broader context. Because it seems to me before you reach dispute resolution, then you perhaps ought to be also considering dispute avoidance, so prevention. And here, of course, the immutability, the irreversibility that colleagues have spoken about in the course of the webinar, attributes which are inherent in a smart contract, become a very big plus, because those are the very characteristics that are intended to avoid disputes. So very much a case of dispute, a case of prevention being better than cure. But let's look at those curative elements in a little bit more detail, the dispute resolution side of things. And one approach may be to pose the question, will judicial enforcement be replaced by algorithmic enforcement? And here it seems to me that it might depend on the type of contract that you're dealing with, going back to what Fergus and Paul were talking about, and contracts which are smart and pure, wholly smart contracts, cradle to grave, beginning to end, conception to implementation. Embodied in code, those contracts may be susceptible of algorithmic enforcement. But as soon as you go outside and you look at contracts, smart contracts as an adjunct to natural law, natural language contracts, then I think it's back to what Joe was saying in relation to dispute resolution in the TCC in courts or in arbitration or similar. And I say arbitration or similar because this does bring me now back to the digital dispute resolution rules. Because the rules talk about resolution by arbitration, but also resolution by expert determination. And as Joe was saying, it requires a rapid reaction response. The determination should be within a month. It also provides for the arbitrator or the expert to implement the decisions directly on-chain using his or her private key. It preserves the optionality of anonymity. Everything, of course, would be subject to the Arbitration Act 1996 if it's an arbitration resolution. So the seat would be in England, subject to the laws of England and Wales. Evidence and argument would be received electronically. And interestingly, there is specific provision in the rules for legal effect to be given to automatic dispute resolution processes. Going back to the example of consumer contracts, if you have online dispute resolution of consumer contracts and enforcement through a smart contract, then automatic payment provisions on the consumer succeeding in the online dispute resolution itself would be automatic. It would be implemented straight away by the smart contract. So if we look at the rules themselves, they start with a statement of purpose. You've got a set of definitions, including what a digital asset is. That's very important for clause 11, which I'll come back to. Talks about incorporation of the contract, the dispute resolution rules into the smart contract. The commencement of proceedings, it's very much a sort of one-shot approach with everything being bundled up together, again, saving time. And the power in relation to the digital assets is, I think, the most interesting clause in the DDRR. Clause 11 says as follows: the tribunal shall have the power at any time to operate, modify, sign, or cancel any digital asset. Going back to the definition that we've already seen of digital asset in the definition section. So operate, modify, sign, or cancel any digital asset relevant to the dispute using any digital signature, cryptographic key, password, or other digital access or control mechanism available to it. It seems to me that those are quite wide powers, but given the immutability of smart contracts, to what extent will an arbitrator be able to operate, modify, sign, or cancel any digital asset as so defined? I hope what I've done in the relatively short time is to give a quick summary of the digital dispute resolution rules. They are, as I say, in draft, in a speech on the 10th of March, Sir Geoffrey Voss, Master of the Rolls, said that he was hoping to publish the rules in final form by the end of the month. So I've checked repeatedly, even earlier this afternoon, and so far I've seen no sign of publication of a final version of the rules, but I doubt they will change very much from that which has been put out for consultation. So that concludes the formal part of the webinar. It's been a pleasure to present, and now we have the chance to respond to questions from the audience. So Sajid, I'll hand back to you to host the questions and answers. Thank you very much.
Thank you very much, Michael. The first question we have is from Neil. How do smart contracts deal with assigning liability? Michael, perhaps in fact we could return to you to answer that question.
Well, yes, it's a very interesting question, because assignment, obviously, as we know, can be legal or equitable. And if one's looking at legal assignments under whatever it is, Section 136 of the Law of Property Act, then there are certain requirements which have to be put in place. And one of the requirements, for example, is that it be in writing. So that goes back very much to the discussion that Paul and Fergus had. One aspect that they were talking about was what satisfies the requirement for in writing. Of course, if you comply with all of the requirements and an assignment is then uploaded onto a blockchain environment, or is it encompassed in other form within the smart contract, then what you do have is a very clear statement of the assignment, and that is itself going to circumvent difficulties. So there may be challenges in making sure that you've satisfied the requirements under the smart contract and that you're sort of Section 136 compliant. But once you've done that, you're in a position of strength, because it's very clear that an assignment has taken place.
Thank you, Michael. We also have a question from Professor Lisa Short. The question is this: moving forward, the data triggers from oracles may change from data to outcome measure, agreed by consent at design level of smart contracts. Is the law still trying to match legal jurisdiction to technology, rather than redesign legal jurisdiction to technology? Given the first operating smart contract occurred in 2015 on Ethereum using Solidity, and now can run on other blockchains, this and BC will require new skills for legal practitioners, particularly audit of code. How do you see that happening? Fergus, perhaps we could come to you on that one.
Yes, absolutely. Well, in relation to the first part of the question, is the law trying to match legal jurisdiction to technology? Undoubtedly, the answer to that question is yes, as we stand. We've got the UKJT's statement, which doesn't shy away from framing issues of smart contracts in traditional legal terms. And for the moment, while we've still got the idea that ultimately a contract is formed when there's an accord and meeting of minds, that's going to continue to be the case. And smart contracts, the technology and the description of the workings of smart contracts are going to have to adapt to that formulation of the law. So that's very definitely my answer to the first one. Whether or not that will change over time, I think that's a very difficult question, and it may partly go to the idea of self-regulation, because the concept of oracles being used as an outcome measure touches on that issue of self-regulation of a smart contract. But it also goes to the second part of Lisa's question, which is about the skills of lawyers. And as we stand today, the question being, is there going to be a requirement for new skills for legal practitioners to do with audit of code? How do we see that happening? I don't see that happening at the moment, other than by the heavy use and reliance on experts. Now, it may be actually that one might say, well, using experts, those aren't really legal skills, so what's the problem? I think the difficulty with that kind of answer is that arguing over the meaning of terms is the legal skill. That is the skill that lawyers deploy when they argue over the meaning of contracts in court. So it's not quite although experts can always help, bottom line is lawyers are going to have to adapt to learning how to, learning some kind of way to translate the terms of a smart contract into something that can be argued over where there's dispute and where contractual terms need to be audited in some way. that may ultimately come down to the use of natural language versions of the code, in turn bringing us back to the problem of what counts as the contract if a natural language version of code is used. Sajid, you're on mute.
I did what I always tell everyone else to make sure they don't do. Michael, is there anything you would like to add to what Fergus has just said in answer to these?
Well, just very quickly, because I agree with everything that Fergus has said, but I must say I think this is a fascinating subject area of this interface between law and technology, the legal profession, and how lawyers are going to have to change in terms of being equipped to do their job in the future. And this idea of whether artificial intelligence is going to be a substitute for lawyers, or whether lawyers' work is going to be augmented by artificial intelligence, is a very hot topic of discussion. I think it is very interesting. I think there will be some very big changes, and lawyers will increasingly have to understand coding, and at least how you take law and put it in code. So you've got to understand how to drive the car, even if you don't understand how every part of the engine works under the bonnet. But I think that that is still quite a stretch for the legal profession.
Thank you, Michael. We have another question, in fact, from Neil. As smart contracts are encapsulated in code, and so much code is poor quality, leading to security vulnerabilities, how can we be assured of the integrity of a given smart contract implementation? And Neil goes on to say, I do appreciate the concept of tamper-proofing on blockchain is solid, but as we have seen with cryptocurrencies, there have been no shortage of security incidents due to implementation issues. Paul, perhaps I could bring you in on this question.
Certainly. I think actually the answer to this echoes a lot of what's been said already, and I certainly agree with Neil's concerns. I think integrity is a real concern, and you could perhaps look to DLT and blockchain technologies as one answer to issues of integrity, but things are almost certainly still going to go wrong, particularly if contracts are designed to last for an extended period of time, and if you start thinking about external events and data sources. So you need to start thinking about how you deal with the problems that might arise. You might have fraud monitoring and prevention services or verification processes in the smart contract, so you might have some technical solutions, but you might also have legal solutions as well. You might need to think about indemnity agreements, contracts to apportion liability, performance and enforcement mechanisms outside of the smart contract itself, and those might take the form of a natural language contract or another smart contract, depending the route that you go down. But I think the thing that's clear, and that everyone else has touched on as well, is that lawyers operating in this space, they really need to be mindful of how both the law and technology can respond to the challenges that come up.
Thank you very much, Paul. We have a question from Frank. Thinking copyright, should we be looking to accommodate special measures to ensure that copyright is not an obstacle to the implementation and enforcement of smart contracts? Michael, again, could I come back to you on this question?
Yes, I think it points up one of these perennial tensions between an area of the law which can act as a protectionist influence on the development of another area of law. So here the question really raises the tension between intellectual property and smart contracts. There's another closely related tension, I think, between the GDPR and smart contracts, where on the one hand you have data protection, but on the other, smart contracts very often rely and depend on data retention. And it does seem to me that one alternative way of looking at this would be to say, well, if you're developing modular, if the smart contracts are going to develop in the modular way that Paul and I were discussing, then maybe there is a role for open source technology, a sort of Wikipedia and Linux approach. Now, you may have some rather aberrant postings in the initial stages, but it's a concept, I think, which could be played with, and which Frank's question made me think of.
Thank you very much, Michael. Joseph, is there anything else you would like to add on that question of copyright?
I think Michael's really touched on it now. I mean, any data programming software is going to be covered by a license. I mean, it's almost like holding people hostage if the license holder is going to withhold use or enforcement of a smart contract that he is in some way providing part of the platform for. So I think it's going to be the area that will need close examination.
Thank you, Joseph. We also have a question from James. It says, I suspect that it will not be possible to have a computer algorithm exclusively defining a party's legal obligations under a contract without a powerful AGI. Again, Joseph, would you like to take that question?
Yeah, I think I totally agree with that. I was talking about the online dispute resolution mechanisms where there's some sort of resolution or decision to be enforced automatically. It's hard to see them working successfully without advanced artificial intelligence that can intuitively determine any scenario that's not been pre-profiled. So that's a long way off. But I refer to the DAOs and the oracles where there's an element of human intervention here, and that's how we overcome that impossibility otherwise.
Thank you, Joseph. Another question, I think this is anonymous. It says, you gave examples of what smart contracts cannot do or are not suited to doing, but for reasons of time, it's just a bullet point list. Perhaps you could say a word or two about a couple of the more surprising problem areas. Why might delivery pose a problem? And why might a smart contract not cope with the voidability? Michael, would you like to answer that question?
Yes, very quickly. Let's take delivery. If you go into a shop and you buy something, then the delivery is obviously over the counter. It's very clear. But if you're loading something for international carriage of goods, then the delivery may be at the docks, it may be when it crosses the ship's rail, and there are all sorts of more intricate judgments which have to be brought to bear in relation to delivery. So, in other words, even quite straightforward terms may pose unexpected difficulties in coding for a smart contract. Another example I gave was voidable contracts. If you have a contract which can be avoided, but where the party who has the power to avoid chooses not to, how does a smart contract on an if ... then ... cope with that continuing option at the behest of the party who could avoid the contract? Just a couple of examples.
Thank you, Michael. We're pretty short on time. Perhaps one more question, and then we'll conclude this session. Brian asks, what is the likely future of blockchain application in government procurement? Joseph, would you like to answer that question?
Yes, certainly. I think tantalizing, interesting question there. I mean, my off-the-cuff answer would be that it would be useful in the selection process so that there is programming and processing of the tenders that are coming in, and then whether the reward stage or the selection phase. So that's how I would see it. There's a faster programming of the compatibility or compliance with criteria. But very interesting question.
Thank you very much, Joseph. That is all we have time for in this webinar. All of the panelists are happy to be contacted by email or connected on LinkedIn. I would like to conclude by thanking all of the panelists for taking the time to share their thoughts and insights on smart contracts. We do hope you will join us again for the next seminar in the Cyber Law series on the 29th of April. And it's on cryptocurrency regulation. An invite will be sent out in the coming weeks. And thank you to all of the attendees for joining us today. Goodbye.